Good morning, honorable members. It is 10.
Recording in progress.
And I think we should, we should start with this meeting. I'm just going through attendance, but also indicating that we've received no apologies. We have Honorable Bartlett, Honorable Fisser, Honorable Nkosi, Honorable Mikalakis, Honorable Nita, Honorable Seleku, and Honorable Zanamela on the platform at the moment. I understand that Honorable Bidobi is also expected to be joining the meeting. However, I don't see him on the platform yet, and Honorable Mtiko. But that being said, honorable members, welcome to this meeting. We also have representatives from the Department of Justice who are present to take us through their presentation. We've also been informed that all members, when you do speak, if you could please switch on your video as this meeting is being broadcasted. Unless, of course, you might have some technical connectivity problems, but I think we'll deal with those matters as we move on. Our members will recall that on the 23rd of July, we received the department's responses to the submissions of the criminal law or the Sexual Offences and Related Matters Amendment Bill. And on the 28th of July, we received the department's submissions on the remaining two GBV bills, that being the Criminal and Related Matters Amendment Bill and the Domestic Violence Amendment Bill. In our previous meeting, our members, we also agreed that the department and the parliamentary legal advisor would then look into the submissions and deal with drafting on the proposed amendments to the two bills. That being the Criminal Law, the Sexual Offences and Related Matters Amendment Bill and the Domestic Violence Amendment Bill. And you'll also recall that there were no proposed amendments to the Criminal and Related Matters Amendment Bill. So in terms of today's proceedings, the department and the parliamentary legal advisor will now take a committee through the proposed amendments on the two bills, and we'll then open it up for the committee to deliberate further. So our members, will first deal with the Sexual Offences and Related Matters Amendment Bill, and thereafter we'll deal with the Domestic Violence Amendment Bill. The proposed amendments have been distributed to members prior to today's meeting. So I'm going to now hand over to the department. I'm not sure who's leading the delegation. Is it yourself, Ms. Pillay? Ms. Pillay, your signal is not very good. I'm not sure if it's just myself, but I cannot hear you.
Switch on my video for the initial part of the discussion, but I see the connection is not very good. So if you permit me, if I may switch off the video. Okay, Chairperson, am I audible now?
Yes, you
Chairperson, am I audible now?
Yes, you are.
Okay, if I may proceed.
Okay, honourable members, it looks like Ms. Pillay has been kicked off the platform. Can I request Gershwin or Zolani to maybe just follow up?
I'll follow up, Chairperson.
Thanks, Gershwin. I know Ms. Pillay is not here.
Sorry, Chairperson, I'm back. I was disconnected briefly. Am I audible?
Yes, you're much better now.
Okay, thank you, Chairperson. I will keep my video off because it's making my connection unstable. Good morning to the Chairperson and honorable members and my colleagues on the platform. Chairperson, I will be leading the delegation today. Mr. Dupriya will deal with the criminal law sexual offences proposed amendments, and I will deal with the domestic violence amendments, proposed amendments to the committee. Mr. Dupriya will start. Chairperson, the document that we submitted regarding the proposed amendments to sexual offences, I just want to point out right up front that there's no changes to that document. However, on the domestic violence amendment, there are several other changes, but more to spelling issues that we picked up in the bill, and also to the use of gender neutral terms. We left out a couple of references in that regard. We're proposing a clearer definition of functionary, and we will be making a suggestion on the schedule to the in respect of an amendment to the Criminal Procedure Act. However, when I flag the document, when I do the domestic violence, those changes will appear in track changes so that I do not cause confusion insofar as the document that has already been submitted to the committee. Chairperson, if that is in order with you and the honorable members, we may ask Mr. Dupriya to flight his presentation so we can so he can start.
Thank you, Mr. Dupriya.
Morning, Madam Chair. Good morning to the members of the committee as well and colleagues on the platform. If you will allow me just a second so that I can share I trust that you can hear me, Madam Chair, and that you can see the document on the screen at the moment.
Yes, we can. Please continue.
Thank you, Madam Chair. Madam Chair, what we have done is, and that was just a question of being used to it, we have prepared a C list, but if we are correct, we understand that since it is a 75 bill, the proposed amendments will most probably end up as an annexure to the report of the committee. So please bear with us. We have prepared it in the format of the C list because that is what we are used to. Madam Chair, when you look at the proposed amendments to the Sexual Offences Amendment Bill, if I may call it that for short, the change that was or that is proposed to the committee will recall that the South African Human Rights Commission recommended that with regard to the definition of vulnerable person, it's more appropriate to refer to a person with a mental disability rather than a person who is mentally disabled. What we have proposed, Madam Chair, is then, of course, to include that amendment in the definition of vulnerable person. However, there are other consequential amendments to be affected to the bill, and I will take you through that shortly. But we would like to argue, Madam Chair, that these amendments are merely consequential in nature. It's actually nothing else than changing the term or amending a term or a definition. So we do not feel, or we are of the view that it does not go beyond the ambit of the bill. But be that as it may, Madam Chair, and I trust that the committee members do have copies of the bill in front of them. I will not be able to share that on the screen at the moment. So if we do not have the bill in front of us, the proposed amendments might seem confusing at times. The first provision or proposal then is to insert a new clause in the bill, which aims to amend Section 1 of the Criminal Law Sexual Offences and Related Matters Amendment Act, which is our definition section of the Principal Act. And here we get the first reference then to that consequential terminology amendment, if I may call it that in short, and that is to replace the phrase person who is mentally disabled with the phrase person with a mental disability. Section 1 also contains a definition of a person who is mentally disabled. So once again, we've got that consequential terminology amendment to refer to a person with a mental disability. And then also in Section 1(3)(d), there's also a reference to a person who is mentally disabled to be replaced with a person with a mental disability. Now, Madam Chair, strictly speaking, it's not necessary to renumber the clauses because that is something that is done administratively, but I have decided to rather err on the side of caution. So under clause 1, you will find that the clause number will change now to clause 2 because we've got a new clause 1 proposed in the amendment bill. And then number 2 under clause 1 is also a technical amendment just to ensure that the phrase that we quote there will be replaced with merely a reference to the Principal Act. Clauses 2, 3, and 4 is merely a renumbering, and that is quite straightforward, Madam Chair. Then, Madam Chair, in our Principal Act, we have substantive provisions creating offences in respect of persons who are mentally disabled, and we would like now, in line with the South African Human Rights Commission's recommendation, to replace that terminology with persons with mental disabilities. So the first clause, or our first new proposed clause 6, will then amend the heading to Chapter 4 of the Principal Act. That is also quite straightforward, Madam Chair. I'm not going to bore you with the detail by reading it out. I think it speaks for itself. Clause 7 then aims to insert a proposed amendment to Section 23 of the Principal Act. And Section 23 deals with the sexual exploitation of persons who are mentally disabled currently, and we would like to affect that consequential terminology amendment there as well as where that phrase appears in the section itself. So there's nothing substantively being amended in the offences that are created there. Once again, merely a replacement of the phrase or the terminology currently being used in the Principal Act. Clause 8 then aims to amend Section 24 of the Principal Act by, among others, then amending the heading and then also the subsection 1 of Section 24, once again, just to replace the terminology. And so, as well as in subsection 2A Roman 1, and also in subsection E. Another new proposal or new clause proposed is then the proposed amendment to Section 25 of the Principal Act. Once again, Madam Chair, it's a question of consequential terminology. In clause 10 is the proposed amendment to section 26 of the Principal Act, which deals with using persons with mental disabilities for pornographic purposes or benefiting therefrom, and those are the consequential amendments indicated there. Clause 11 is an amendment to section 30 of the Principal Act. Once again, the amendment of the terminology. Then we are back at clause 5 as reflected in the B version of the bill, which will be renumbered to clause 12. And then you will also note that under number 2, once again, we propose that amendment to the terminology. And then the proposed amendment in number 3 is very important, Madam Chair. You will recall that concern was expressed that persons who sell sex will end up on the National Register for Sex Offenders, and the committee, or it was indicated to the committee that it was never their intention, because those persons cannot be considered as sexual predators for purposes of the National Register for Sex Offenders. So number 3 aims to amend the definition of sexual offence for purposes of Chapter 6 of the Act. You will recall that our definition has got a paragraph A and a paragraph B. Paragraph A is restricted to those offences having been committed against children and persons with mental disabilities. And paragraph B then deals with those prospectively offences being committed, and we exclude reference to section 11, which is then the provision in the Principal Act dealing with the client of a sex worker. This proposed amendment must also be read with the proposed amendment to section 50 of the Act. I'm not going to jump to that now, but when we get there, Madam Chair, I will just merely indicate to the committee and remind the committee that the proposed amendment here must be read with the proposed amendment to section 50 of the Principal Act. Clause 6 will be renumbered to clause 13. And then this is where I think, if I may say so, the devil's printer, or the printer devil, intervened. This is something that we have to correct. In the B version of the bill, it was something that unfortunately slipped through, and we have to correct it because it was approved by the Portfolio Committee, but it is unfortunately something that slipped through. So this is a technical correction. It's not, strictly speaking, a new proposed amendment by the Select Committee. And same with number 3. At number 4, we will see the correction of terminology again. Clauses 7, 8, 9, 10, 11, and 12 will be renumbered. So those proposed amendments are quite straightforward, Madam Chair. With regard to clause 13, you will recall that, if I remember correctly, it was the Western Cape government, the MSC, that recommended or pointed out to the committee that section 47(1) is not amended because there is still reference to a child or a person who is mentally disabled. In the B version of the bill, there is only a proposed amendment to subsection 2. So what we would like to propose to the Select Committee is to rather than reject the clause as it stands in the bill itself, and then merely to insert the proposed amendment to section 47(1) by replacing reference to a child or a person who is mentally disabled with the person is already in the B version of the bill. Clauses 14, 15, 16, and 17 will have to be renumbered as a result of the proposed new clauses. 14 currently in the B version then deals with the proposed amendment to section 50 of the Principal Act. And section 50 of the Principal Act deals with with persons whose particulars must be included in the National Register for Sex Offenders. You will recall under clause 5, I have indicated to the committee that reference to section 11 of the Principal Act will be excluded. Now, when we look at section 51A of the Principal Act, there is reference to, in terms of this act or any other law. And if I remember correctly, it was Sweat or another organization who indicated that this phrase might cause interpretation problems. The department agreed with that proposal, and in order to ensure that there is no confusion with regard to whose particulars must be included in the National Register for Sex Offenders, we recommend to the committee that reference to in terms of this act or any other law should be excluded from that introductory part of section 51A. This is sort of, these words or the reference to this act or any other law is strictly speaking redundant now, Madam Chair, because of the fact that the bill now proposes that the definition of sexual offence should be included in Chapter 6 for purposes of that chapter. Then clauses 17, 18, and 19 is also merely a renumbering of those clauses. And then with regard to the proposed amendment, and this is a new clause, if approved to be proposed by the Select Committee, is then an amendment to section 57 of the Principal Act by, among others, then replacing the reference or the phrase persons who are mentally disabled with persons with mental disabilities, and then in subsection 2, the amendment of a technical nature, in other words, replacing the term. Clause 20 is also a renumbering. Clause 21, Madam Chair, is the proposed amendment to the long title of the Act. And the proposal is that the long title should be amended to be in line with the proposed amendments of the Select Committee if approved, and especially then paragraph C.
Recording stopped.
Where there is a reference to persons who are vulnerable. Clause 22
Recording
is
in progress.
the proposed amendment to the index of the Principal Act. And as you see, we need to align the index to the Principal Act with the proposed amendments. Those are, to a certain extent, for a drafter, what we would like to call technical amendments, Madam Chair. It's not of a substantive nature. And then, as well as the proposed amendment to section, or the reference to section 41 in the index to the bill. And you will recall that in chapter 6, the B list of the bill already proposes the insertion of two new sections in the Act. So those are also, strictly speaking, straightforward. The proposed amendment under clause 23 is merely a renumbering. And then lastly, Madam Chair, reference then is made to the long title, in which the second bullet of the long title, a new paragraph, a new bullet will be inserted after the second bullet of the Principal Act to indicate that the bill also aims to replace the terminology persons with mental disabilities. And Madam Chair, that is the conclusion of this presentation. With your permission, I will stop sharing the document then, Madam Chair.
Thank you very much, Mr. Dupriya, for the presentation. Members will note that the presentation is in line with our previous deliberations, and a lot of the amendments being technical of nature, of the bulk of it. And there are new clauses being inserted, which is as a result of us amending reference to mental disability, where we're replacing the term with a mental disability by who is mentally disabled. And the other amendments that also relate to some of the corrections, or if I may say omissions, that were not effected in the previous version of the bill, in the previous amendments. On members, I'm going to open it up to yourselves if you have any questions or comments that you would want to make. Obviously, bearing in mind that this is pretty technical, but also I think Mr. Dupriya, the numbering issue as well also creates the impression that there are a lot more amendments, because there's about 16 clauses, I think, within this bill that are just the amendments are as a result of numbering. But be that as it may, honourable members, do you have anything you would like to ask or comment on? If you're in agreement as well, I think that would also be okay. Okay, I'm seeing no hands being raised. I think maybe then let us go into the next presentation. Ms. Pillay, the Domestic Violence Amendment Bill. Ms. Pillay.
Thank you, Chairperson. Is my screen visible?
It's visible, but
screen visible?
Yes, it's visible, but we cannot hear you very clearly. Ms. Pillay?
Okay. Am I audible now, Chairperson?
Yes, you are.
Okay, thank you very much, Chairperson. As
Okay, honourable members, it seems that we've lost her again. Zolani or Gershwin, if you could make a follow-up, please.
Will do, Chairperson.
And is there any way of somebody else projecting her presentation? Because clearly she's having issues with her connectivity. Or members, if you could just bear with us. Thanks.
Chairperson, I'm back in the meeting. Can you hear me?
Yes, we can hear you, but your presentation is not on the screen. I'm just wondering, is there someone else who can project for you while you speak? Because I think when you're trying to do both, it's affecting your connectivity.
Yes, possibly. I'm going to try one more time. I've changed the way the computer was. Chairperson, is it visible now?
Yes, it is.
Okay, I'm going to try and take you through this. Hopefully there will not be any further interruptions, and I apologize for that, Chairperson. The amendments that we propose are in line with the comments that were received, and also in line with the broader decision that we took, that the language that we present in the bill must be gender neutral. And in that regard, we'll be proposing a new amendment to cover the entire domestic violence amendment bill. I'll take you through it. There were one or two incorrect references to the definition of to the wording of communications. And instead of saying communications, we ought to have said communication. So it's those kind of minor issues that I will raise as we go through the document. So let me start on clause 1. We are inserting in the index a 19A, period within which the directives and regulations must be submitted to Parliament. That arises out of comments that were raised that this was actually an omission in the bill. We have addressed that now. In clause 2, Chairperson, on page 3, lines 31 and 32, there were also comments raised regarding the wording of this. This was a technical amendment as well, to delete the words prescribed in terms of section 6A and to replace it with provided for in directives contemplated in section 6A3 sub 1. Chairperson, the next point we want to raise in clause 2, as previously stated, the definitions clauses where the gave rise to the bulk of the comments that were received on the Domestic Violence Amendment Bill. On page 3, after line 41, we want to insert a new definition of close relationship, which means a relationship between the complainant and any other person, which the court, with regard to the following criteria: A, the degree of trust between the persons, the level of each person's dependence on and commitment to the other person, the length of time the relationship existed, the frequency of contact between the persons, or the degree of intimacy between the persons, may consider as a close relationship of a person with the complainant. This is a new definition entirely, Chairperson, which kind of takes the previous wording, but gives the clarity that was required based on the comments that were received. On page 3 in line 42, this is where we bring in the gender neutral terms, and it goes from point 3 to 9 on clause 2. On page 3 and line 42, we are changing he or she has to they have. In line 43, we are changing he or she to they have. On page 3 in line 53, there were also comments in regard to the use of the word is aimed at, and we are replacing it with as the effect of. On page 3 in line 55, we are deleting him or her with them. In line 4, we are deleting his or her, and we are replacing it with their. On page 4 in line 2, we are deleting him or her, and we're going to replace it with them. On page 4, in line 4, we delete his or her, and we replace it with their. On page 5, after the word pictures, we are inserting that are real, simulated, or manipulated. These were comments that were received from the group called Alt Africa. Chairperson, there's a new point 11, 12, and 13. Now, on the screen, you will see that I have not changed the wording, the numbering of the original document that we submitted, because we did not want to now refer to new numbering based on the document that we had already submitted to committee members. I think if the chairperson and the committee approves of it, we will change the numbering and submit it to the parliamentary legal advisors after this meeting, if it is in order that we bring about these additional changes after the document was submitted to yourselves. But I will take you through them, and you will see that many of them are merely corrections to spelling. On page 50 in line 50, on page 5, line 50, we refer to communications when it ought to be communication. Throughout the bill, we've noticed that we refer to electronic communications, and it should be electronic communication without the S, and that is in line with the ECTA Act. And it actually reads better to say electronic communication. So we've standardized that wording throughout the amendment bill in this document. So in page 5, it's a similar change. Page 5 in line 55, we change it to communication to communications service. So it's a minor adjustment to clarify the wording. So electronic communication service should have been electronic communication service with an S. On page 5 in line 57, so throughout the document, Chairperson, these are the changes that we will be making in respect of the use of the S, communications with an S and without an S. Electronic communication service in page line 57, electronic communication network. On page point 11, page 6 in line 6, it's a change of the numbering in respect of, it should actually have an underlining. The current amendment bill as an and 4, so that's merely the underlining that we are correcting in that regard. Point 14 of the document, in line 9, we are deleting the subparagraph E, which was not indicated in the original, in the bill, in the amendment bill. On page 6 in line 9, we underline education expenses because it is an insertion. On page 6 in line 9, we delete all. On page 6 in line 9, we are inserting the transportation costs. This is also as a result of comments that were made during the consultation process. On page 6 in line 10, we are deleting the F in bold. On page 6, line 10, we are deleting the numbering to correct it from 6 to make it Roman numeral 7. Point 20 on the document in line 6, in page 6, line 12, after child, we are inserting person with a disability or older person to broaden the group that was originally submitted, that was originally drafted in the amendment bill. On page 6 in line 12, after complainant, we are inserting to whom the respondent has a duty of care. I think comments were raised in this regard that there's a lack of clarity, and this is in response to that comment. On page 6 in line 22, we are deleting is such as to, and to replace it with a deletion of is such as to constitute. In the amendment bill, we did not extend the deletion to constitute, so we're correcting that. On page 6, line 22, we are deleting constitutes and to replace it with constitute with an S, constitutes. Page 6, line 30, we are deleting against and we are replacing it without. Page 6, line 30, we are deleting wishes and we are replacing it with the word consent. Members will recall that there was a comment in that regard as well, that the word consent should be used instead of wishes. On page 6 in line 38 to 45, we are deleting the entire definition of functionary and we are replacing it with the following definition. A functionary means a medical practitioner, a healthcare practitioner, healthcare personnel, a social worker, an official in the employ of the public health establishment, an educator or a caregiver, and any person designated, and sub B, any person designated in terms of section 2A3. So Chairperson, we are deleting the entire definition because trying to clean it up appeared to be very untidy and there was a lot of misunderstanding in terms of what we are actually saying. So we felt it would be better when we amending or to propose an amendment that just cleans out just the removal of words in paragraphs, and we clean it up in the proposed by just proposing a new definition of functionary, which is more or less what's in the bill, but just in a much neater version. On page 6, in line 41, it's the same relates to the definition of functionary. So we no longer require line 27 on page 4 of the document that's before you if we clean up the definition of functionary in the manner that we proposed. On page 6 in line 49, we insert the word stalking after the word watching. There was a lot of comment that related to the inclusion of stalking in the definition of harassment, and we've now attended to that by including it in the bill. On points 29 to 30 of the document before you, Chairperson, there's the gender neutral terms where we are changing he or she and we are replacing it with they. And if it's in order, I will not repeat those because they relate to the same changes from page 6 to 7, line 54, 21, and 31, respectively. On page 7, in lines 36 to 37, we are deleting by the Director General of Health and to replace it with as a functionary. On page 7, line 38, we're deleting section 18B and to delete as a functionary. After the word, Chairperson, let me be more clear about that. After the word section 18B, we are deleting as a functionary. On page 7 in line 47, we delete the word or. On page 7 in line 49, we delete so and to replace it with so with the and or after the so with the semicolon in between. On page 7 in line 49, we insert the following. D, conveying a threat or causing a complainant to receive a threat which includes fear of physical violence or damage to property belonging to a complainant or any other person through electronic communication. This chairperson is also as a result of a comment that was made during the process. On page 7 in line 6 and line 7, again, it's the reference to the word communications, which ought to have been communication without the S. On page 7, line 51 and line 52, it's the gender neutral term of he or she has to replace with they have. On page 8, to delete person up to and including complainant in line 17. On page 8, again in line 33, to delete permission and to replace it with consent. Now, line 41, you will notice that there's 2 lines. The one in track changes, where my cursor is currently on page 8 in line 50, to delete as abuse. This is just cleaning up the wording that's in the amendment bill, Chairperson. It doesn't change the substance of the sentence, but it just reads better the way it is proposed now. On page 9 in line 18, again, it is the gender neutral term to replace he or she with they comply. Moving on to page 5, on page 9 in line 23, we need to underline the NO dot in reference to the piece of legislation that we are referring to clean up the presentation of the piece of legislation. On page 9, from line 29 to 34, we change the to make the term gender neutral, his or her, we are replacing it with their. These, Chairperson, from line, you will see there's 2 lines, 43 to 45. The insertions are in track changes where my cursor is currently are the ones that we did not include in the original submission. And if the committee is agreeable to us submitting it now, we will then renumber and submit same to the parliamentary legal advisors. On page 9, in line 60, we insert after the word act, and we insert which. Then there's a further omission. We refer to protection order in the bill on page 10 in line 2, and we want to insert the word a protection. It should read a protection order, so we merely insert a in that proposal. Line 44, after paragraph A, we want to insert against a third-party actor. That is also a comment that came through as a correction, a technical correction, which we accepted during the consultation process. On page 10 in line 6, it's also a grammatical change that we are proposing subsequent to our submission of the original document. We want to delete to have and to replace it with having. I referred to a new clause, Chairperson, and in this regard, the new clause is merely, again, the gender neutral terms. The Act in section 2 makes reference to his or her, and the reference should actually be to their, and that is proposed in the new clause, what we propose as a new clause. Moving on to clause 3, on page 10 in line 11, after 2A, we insert the minister may, by notice in the Gazette, designate any other person belonging to a class or category of persons, or who is in the employ of any class or category of entities as a functionary. This is also as a result of the comments phase to just give clarity to the meaning of the word functionary. On page 10 in line 11, we delete the 1 and we replace it. It's a numbering issue, Chairperson, and we replace it with a sub 2. On page 10 in lines 11 and 12, we delete his or her with their. On page 10, it was an error in the original submission that we are correcting by way of track changes. it's exercise of, not exercise to. So it's exercise of as the deletion, and to delete is or her to replace it with their. On page 10 in line 13, to delete by him or her, causes him or her, to replace it by them, to cause them. Again, the gender neutral correction that we want to bring about in this bill. Page 10 in line 22, to delete prescribed in terms of and to replace contemplated in. This doesn't change the meaning of the word. It actually clarifies it based on the comments that were received, that it's contemplated and not necessarily prescribed, which has a different meaning. On page 10 in line 27, it's also a numbering issue that we are correcting. And it goes on to points 9 and 10 of this clause 3 as well. On page 10 in line 32, we are deleting his or her to replace it with their. On page 10 in line 36, it's a numbering issue as well that we are correcting. In clause 4, page 11, line 12, we delete he or she and we replace it with they. Line 13, it's a correction in terms of the spelling. It should be believes and it should be believe and not believes. Page 11, line 34, we delete maybe prescribed in terms of to replace it with contemplated in. Clause 5, page 11, line 48, we delete him or her to replace it with them. Clause 6, page 12, line 24, to delete another and to replace with a functionary or another. On page 12 in line 38, we delete the word who is who is under the age of 16. Chairperson, this referred to the definition of a child, and there was a comment that this creates confusion as the definition of a child is someone below the age of 18, and this word just creates a lot of confusion, so we are deleting the word who is under the age of 16. On page 12 in line 39, to delete the child and to replace it with that child. Point 4, on page 12 in line 55, after subsection 1B, we insert the words any supporting affidavit. And on page 12 in line 58, after the word must, we insert immediately. This is also in response to comments that were received that we needed to be specific insofar as the timelines are concerned for the submission of documents. Clause 7 on page 13, lines 38 to 39, we delete within the area of jurisdiction of the court and we replace it with servicing the area where the complainant resides. On page 13 in line 45, we delete complainant and to replace it with complainants with an apostrophe S. Chairperson, point number 3 is a new insertion where we picked up a spelling mistake in the amendment bill. And I'm told that we need not necessarily raise these issues in the committee. It could be done with the Bills Office. However, we thought that we would mention them in this document and we can take it further insofar as how we fix these issues in the bill. The spelling of Director General was actually incorrect in the published amendment bill. Clause 8 on page 14 in line 29, to delete, it's again a typographical, it's a numbering issue, to delete 41B sub 2, Roman numeral 2 or 7, and we want to replace it with 41B and to delete the reference to sub 7. On page 7, from the words and in line 36 up to and including out, to delete all the words and to replace it with the following. Now, Chairperson, this appeared to be a little bit confusing the way it is presented. But if you look at the original bill, there are some deletions, and it makes the reading of what we are actually deleting very confusing. So we are just clarifying what needs to be deleted in that on page 14 in line 36. It's a cleaner deletion, in other words. On page 41 in line, page 14 in line 41, we are inserting a proper reference to the Act to make it uniform. Act number 42 of 1987. On page 15 in line 25, after protection, we insert the word order. And on page 15, line 39, after order, to insert and of the return date into the bill. On page 15 in line 53, to delete, brought to the attention of, to replace it with served on. This was also a comment that was made in respect during the consultation phase. In clause 9, page 17 in line 10, we delete the word questions and to replace it with question. And on page 17 in line 61, after the second two, we insert the word immediately. On page 18 in line 4, to delete form and manner and to replace it with the following: manner by means of an affidavit in the prescribed form. On page 19 in lines 4 and 5, after resources, we delete in the prescribed manner. On page 19 in line 8, after service, to insert provider so that it reads service provider. On page 19 in line 18, to delete 6 sub C and to replace it with 6A. On page 19, to delete the words it may. On clause 10, page 20 in line 2, to delete or is committing and to replace it with or is committing. I think, Chairperson, this is a typographical error insofar as what needs to be, how the bill is presented in the as a technical amendment. On page 20 in line 29, from 2A up to and including date in line 34, to delete all the words and to replace it with the following. 2A, 2 capital A, sub A, if the respondent appears but the complainant does not appear, or where both the respondent and the complainant do not appear on the return date referred to in section 5.3, the court must extend the interim protection order and the return date, and the court must notify 1, the complainant, or 2, the complainant and the respondent where both did not appear in the prescribed form and manner of the return date. Chairperson, this was a comment that was raised. How would the complainant know that the matter is going to be back in court? And we needed to clarify that where the complainant does not appear, that there should be, where both parties don't appear, that they should be informed in a prescribed manner of the extended date so that they could make, so that they could be either in court or allow the matter to be decided in terms of the provisions of the Act. On page 21 in line 5, after respondent, we insert within 48 hours or so soon, or as soon as reasonably possible. This was also a comment insofar as the service of the document on the respondent, and within 48 hours or as soon as reasonably possible. Because not all respondents will be, there may be an instance where it cannot be served on a respondent within 48 hours, but this is where what we set as the bar for the service of the document. On page 21 in line 26, to delete brought to the attention of and to replace it with served on. Clause 11, in line 21, we just delete the comma after the must. On page 21, Chairperson, it's an insertion in terms of the gender neutral terms, to delete is or her and to replace it with their. Same with line 50 to replace him or her with them. And in line 56 to delete prescribe and to replace it with provide for. In clause 12, page 23, line 16 to delete he or she and to replace it with they. In line 27, after home to insert study, and same with line 32, and this is a direct response to the comments that were received. Clause 13, line 24, sorry, page 24, line 42, to delete the apostrophe. It's actually just a correction. On page 24, after line 42, to insert a paragraph C into the amendment bill by the insertion of sub 5 of the following subsection. And in this regard, Chairperson, we are changing the gender neutral to make the term gender neutral, his or her, which we changed to they. Clause 14, himself or herself on line 54, page 24 to themselves. And Chairperson, in the original document that we sent to you on line, point 2 and point 4 of the submission that we made, we need not delete these words because they've already been catered for in the amendment bill. So that was an error on our part. Just to point 3 on page 25 in line 45 to delete the full stop and the word and to replace it with a semicolon and a hand. Clause 15 on page 25 in line 55 to delete he or she opposes and to replace it with they oppose. On page 25, line 56 to delete the word receiving. Page 25 in line 56 to delete A, the sub A in brackets and to insert being served. To insert it after sub the A. On page 25 in line 59 from sub 2 to delete everything up to and including voluntarily. On page 26 in line 2 to replace the following. This should actually be, just need to correct this wording and the numbering to replace the following. If the court is satisfied that A, circumstances have changed materially since the granting of the original order, B, and delete and that good cause has been shown for the variation or setting aside of the protection order, and to add a C, proper service has been effected on the respondent, it may issue an order to this effect, provided that the court will delete the shall, may not grant such an application to the complainant unless it is satisfied that the application is made freely and voluntarily. Clause 17, line 26, page 26, line 20, we insert the word studies after resides. Clause 19, page 26, line 49 to delete the provisions of. And on page 27 in line 1, again, it's a correction to delete communications and to replace it with communication without the S. Clause 23, on page 28 in lines 54 to 56 to delete all the words from in up to and including and to replace it with the following. In consultation with the cabinet members responsible for health, social development, basic education, higher education, science and innovation, police and communications and digital technologies. On page 29 in line 9, after must, we insert provide for. On page 29 in line 10 to delete prescribe. On page 6 to 12, we delete the word prescribe on line 12. We delete prescribe in line 16. We delete prescribe in line 18. And we delete provide for in line 22 and 28. And we delete prescribe in line 29 to 31. On page 29, after line 33, we insert the following. The directives referred to in this subsection must ensure that adequate disciplinary steps are taken against a functionary or person who fails to comply with any directive. Chairperson, this was not included in the bill, and it came through in the comments through the select committee, and it has been inserted accordingly. Page 29 in line 34, to delete 3 and to replace it with 4 because of the addition of the clause that I just read. Clause 24 on page 30 in line 2, after the first 2, to insert the complainant, comma, respondent or. On page 30 in lines 2 and 3, to delete him or her and to replace it with them. In line 30, after line 15, to insert the following. The insertion of a new section in Act 16 of 1998, Act 116 of 1998, 25. The following section is hereby inserted after section 19 of the Principal Act, period within which the directives and regulations must be submitted to Parliament. 1A, the directives referred to in sections 18A and 18B must be submitted to Parliament within 12 months from the date of assent of the Domestic Violence Amendment Act 2021. The Director General, who in terms of section 18A or 18B, responsible for the issuing of directives must, in the event of a failure to submit the directives within 12 months from the date of assent of the Domestic Violence Amendment Act 2021, report such failure and the reasons for such failure to Parliament before the end of the month, following upon the month during which the 12-month period expires, and thereafter at such intervals as Parliament may determine. C, the failure to submit the directives referred to in paragraph A to Parliament within 12 months from the date of assent of the Domestic Violence Amendment Act 2021, does not affect the validity of any directives that are submitted to Parliament after the expiration of the said period and thereafter issued. Sub 2A, the Minister must, in terms of section 19.2, submit regulations that are necessary or required to be made for the proper implementation and administration of this Act to Parliament within 12 months from the date of assent of the Domestic Violence Amendment Act 2021, in terms of section 81 of the Constitution of the Republic of South Africa 1996. Chairperson, I would also like to request an opportunity to discuss this wording with the parliamentary legal advisors, because I'm also informed and aware that this may not strictly be necessary in terms of drafting principles. The Minister must, in the event of a failure to submit the regulations referred to in paragraph A to Parliament within 12 months from the date of assent of the Domestic Violence Amendment Act 2021, report such failure and the reasons for such failure to Parliament before the end of the month following upon the month during which the 12-month period expires, and thereafter at such intervals as Parliament may determine. The failure to submit the regulations referred to in paragraph A to Parliament within 12 months from the date of assent of the Domestic Violence Amendment Act 2021 does not affect the validity of any such regulations that are submitted to Parliament after the expiration of the said period and made thereafter. In clause 25, it's a numbering that we are changing 25 to 26. In clause 26 on page 30, from lines 21 to 49, we delete the words period in line 21 up to and including thereafter in line 49. Clause 27, on page 30 in line 51, we delete Domestic Violence Act Amendment Act. Chairperson, this was an error, and it should read Domestic Violence Amendment Act 2021, and those are the changes that we are proposing. On page 30 in line 54, we delete 26 and to replace it with 19A. On page 30, lines 54 and 55 to delete in terms of section 81 of the Republic of South Africa. In the schedule, Chairperson, we originally submitted some minor changes to the schedule on Section 40 of the Criminal Procedure Act, which is arrest by a peace officer without a warrant. On reflection, Chairperson, we would like to make a much neater proposal insofar as what offense we are going to be catering for, and also to correct the insertion that we add on the original bill, which speaks to an insertion of a paragraph R after Q into the Criminal Procedure Act. Chairperson, I think the insertion of R in the amendment bill should actually be deleted because it is a repetition of what is already catered for in a neatened manner under Q. So we will be proposing just the insertion of Q in Section 40 of the Criminal Procedure Act, which will read as follows. Q, who is reasonably suspected of having committed an act of domestic violence as contemplated in Section 1 of the Domestic Violence Act 1998, and which constitutes an offense in terms of any law. That is the insertion which we will be presenting in respect of Section 40 of the Criminal Procedure Act. And Chairperson, that brings me to the end of this document, and I hand over back to you.
Thank you very much, Ms. Pillay, for the presentation. However, given the additional amendments that you made reference to in your presentation, obviously we would expect you to resubmit the documentation. However, I think in terms of our last meeting, we did task yourselves together with the parliamentary legal advisor to deal with the proposed amendments. And I think in terms of your presentation now, there's still some areas for further consultation. So my proposal is that, honorable members, that we don't necessarily engage further on this bill, on these amendments, but we receive the documentation after the consultation with the parliamentary legal advisor on this, the domestic violence amendment bill. I think I've been a bit lenient with the department, and it's just with the understanding that the department is also at this point in time experiencing some challenges within their legal unit, in that some of their legal drafters are ill and were unable to be part of this process. But I think that being said, honorable members, we'll take further deliberation and discussion on this bill, particularly this one, in our next meeting. So I'm not going to open it up for discussion because I think it would be unfair also to yourselves, so that because you've not received this document before the meeting, but you're receiving it now as being presented. However, the version that will come to you will be the one that doesn't have any gray area, and the consultations between our legal teams are complete. I think that being said, honorable members, if you are not in agreement and you still want to raise a matter, you may, if you could give an indication by raising your hand. I don't see any hands. I'm just going to ask the parliamentary legal advisor perhaps to comment on the criminal law, the Sexual Offences and Related Matters Amendment Bill. If she has any comments on those. Ms. Woods, are you still on the platform?
Yes, good morning, Chairperson. Good morning, honourable members. I'm here. Chair, I followed the presentation of Advocate Dupree, and from what I saw in the previous versions and what was amended, I think I agree with everything there. His comments with regard to the technical amendments required from the public submissions, that all, as I saw it, looks in order. And yeah, thank you, Chair. I would, with your permission then as well, to consult further with the Department on the Domestic Violence Amendment Bill. That will be appreciated. Thank you, Chair.
Thank you very much, Ms. Lewis. Members, my apologies, but I can't control the noise outside. I think with that being said, members, we're still in the process of processing these bills. We will have our next meeting next week, Wednesday, where we further consider these bills. I think with that said, let me thank you very much. Let me thank representatives from the department, and let me declare this closed. Thank you very much.
Recording stopped.